everyone, and welcome to Crime in Court. As I promised you guys in my last episode, I knew there was a new filing from Turtleboy from his defense team, so I wanted to get a video out for you guys today. So this is episode 91 of the Canton cover-up Commonwealth versus Karen Reed and Aiden Turtleboy Carney. Today we're going to be going over Turtleboy's motion for discovery for Morrissey, Michael Morrissey's burner email account. He has a personal email account that he's been using and doing personal or doing business on, and they need to turn that over to the defense, meaning to Turtle Boy. And we're also going to go over the discipline that Detective Lieutenant Tully received for his misconduct, and we'll get to that. So all right, let me shrink myself, and as I do, please hit the like button. It really helps the algorithm, and I also really appreciate it. All right, so this is going to be probably a shorter video. I'm in a lot of pain, so I'm going to try to get through it pretty quick. Defendant's motion to compel Rule 14 discovery and for issuance of Rule 17 summons. Now comes, this is from Mr. Tim Bradle. So Aiden has two attorneys. He's got Tim Bradle, who he's had for a while now, since last year. And more recently, he brought on Mark Betterow, he's YouTube famous, even though he doesn't even have his own channel. He just pops around on other people's channels and talks about this case. And through that, he became passionate about it, and uh, Aiden hired him. So we have that. All right, so, but this is written by Tim Bradle. So now comes Mr. Aiden Carney, defendant herein, and respectfully requests that the court order the production of statements referenced herein below, and further authorize the clerk magistrate to issue a Mass R. Crim. P. Rule 17 summons to Apple Inc. via email as requested by Apple to lawenforcement@apple.com. Is their designated address for court orders. And this is what they're asking for. Any and all emails or text messages sent or received beginning on August 10th, 2023 to the present associated with the Apple iPhone and or iCloud account assigned to private subscriber Michael Morrissey, Norfolk County District Attorney, the subscriber. And I'm thinking they probably chose that date because that's probably about the time, or maybe even a little bit before the time when Turtle Boy started to get his indictment, because I believe in October was when his indictment was the first time around. So, um, yeah, I don't know. I think it was, there might have been there could have been conversations on this personal email account of how are we going to get Carney? How do we get him? If a restraining order isn't working, how can we bring him down? And there could be some, I don't know if there is. I'm not saying there is. I have no idea, but there could have been. So it makes sense that they might want to see what's on this personal email. Also, they want to be provided subscriber personal email address to be provided under separate cover to be filed under preliminary impoundment. Okay, so that's going to be filed under impoundment. Number 2, further that the Norfolk Superior Court Clerk's Office receive and retain the information under impoundment. I feel like they just said that. Number 3, further that the court appoint a special master. So let's scroll down here. This footnote says the district attorney is incapable of policing his own employees where he himself is engaging in improper communications and skirting discovery records requirements necessitating a special master. I like it. He can't be trusted himself. How can we trust any of the cops that he and attorneys that report to him? Because the Massachusetts State Police also falls under Michael Morrissey's authority. So no wonder it's all a mess, because Michael Morrissey is pretty corrupt there. All right, so further, the court wants this special master, independent from but at the expense of the Norfolk County District Attorney, to review the content provided to the court and provide to the parties all Rule 14 discoverable statements between and among the subscriber and any civilian witnesses or law enforcement witnesses or alleged victims, and any ex parte statements, so one-sided statements if a judge and the prosecutor have a conversation without the defense attorney there, that's a ex parte communication. Just as if the judge had it without the or with the defense and without the prosecutor, it's the same concept. So they want any ex parte statements to the judiciary, meaning these judges, that he was talking to in his emails, because we know that Michael Morrissey was talking to some because we received Turtleboy received some discovery, and I think some of it wasn't like even meant for him to find, but he kind of came upon this email that had a personal account of Michael Morrissey where he was talking to Jen McCabe and talking about trying to get Turtleboy to somehow stop from talking, basically, because that's what all they wanted to do was shut him up. So, yeah, these ex parte communications to the judiciary concerning the defendant herein or any other witness or person connected to the defense of the above captioned cases or the pending case in Dedham District Court involving the same complainant. And number 4, that DA Morrissey be personally ordered to provide any other Rule 14 discovery in his possession, custody, or control, whether on paper, storage devices, personal or office devices, and whether situated, including but not limited to the readable, accessible, full extraction from Mr. Carney's phone referenced in the communications. As grounds, the defendant states that the subscriber Morrissey is the chief law enforcement officer of Norfolk County and the ultimate authority over all Norfolk County assistant prosecutors, whether designated assistant or special assistant district attorneys. As such, he is part of, and in fact, the leader of the prosecution teams in the above captioned matters, ethically prohibited, like any other attorney, from engaging in ex parte communications with justices on pending matters. So he's not supposed to be talking to any of the judges about this. He's not supposed to be having one-sided conversations. He's supposed to be impartial. He's supposed to want to get to the truth and not, frame an innocent woman. Likewise, and equally axiomatic, any written or substantially verbatim recorded statements he receives or participates in from civilian or police witnesses or alleged victims are statements that must be disclosed to the defense under Rule 14 of the Massachusetts Rules of Criminal Procedure. Here, the defense team has received and publicly shared whistleblower information that D.A. Morrissey has personally communicated in an ex parte fashion with the then Chief Justice of the District Court, the then presiding Justice of the Stoughton District Court, and other high level court personnel, disparaging the defendant therein. So, disparaging Aiden Carney, because he was communicating with judges who were not not issuing a restraining order because Carney was expressing his First Amendment rights, and these people were going there trying to get him to stop, basically. Like there was no real threat. It's just words. They're threatened by his words and not like he's not a physical threat to them. So, yeah, Morrissey was because they weren't getting the restraining orders. The Chris Albert, Colin Albert, Jen McCabe. Those are 3 of the individuals I know that were seeking restraining orders. Because they didn't get them from the district court, Morrissey then was stepping in because he received something from Jen McCabe saying, I can't believe he didn't get it, meaning Chris, and like just horrified that Turtle Boy, blah blah blah, going and John McCabe. So for that reason, um, Morrissey decided he was going to have some communications with the judges and saying things like, well, you need to be held accountable. You need to make sure that you're doing something about this and blah, blah, blah. So just all around not a good look. And I mean, at the very least, he committed misconduct there. At the very worst, it's corruption at its highest. I mean, it's pretty bad no matter what way you look at it. So, all right. So then he talked to all these then presiding court, district court justices and other high level personnel using the burner account with the obvious intent to avoid scrutiny from the public through public records requests. Like I said, he didn't want to be caught in a FOIA request. So, for that reason, he was using this private burner email so that no one could find these emails. But again, it got leaked unintentionally on his part. Um, so CXB to October, Exhibit B to October 17th, 2024, letter to Special Prosecutor Cosgrove from Co-Counsel Butterow attached hereto in its entirety as Exhibit A. DA Morrissey's communications to the court personnel also contained a screenshot of a partial communication. This is in reference to Rule 14 discoverable. So this was a discoverable statement that they never received. So it's a partial communication from an alleged victim listed in the indictments against Mr. Carney. So that's Jen McCabe. Morrissey complaining about leaks of public information to defendant Carney, according to a number of witnesses in this matter, and appending one such statement in his personal possession in the ex parte communication. Morrissey's illicit communication literally solicits responses from the justices and refers to additional statements justifying the defense inquiry for further documents and communications. Because he was soliciting some kind of a response from these judges, that makes it 100% discoverable because it has to do with the outcome of this case. So, the outcome of Mr. Carney's rights. This has a lot to do with what are we after? The truth or just convictions, which that seems to be the problem here. So, to the extent the district attorney or his agents have gathered such undisclosed statements from a number of witnesses and/or communicate with such persons on their personal devices, the entirety of such statements are discoverable under Rule 14, and the use of a personal device does not sanitize these communications from discovery. So just because he used a personal email doesn't mean that we can't have it. It's discoverable just as much as his work email. There's no difference. Further, the plain language of Rule 14 makes no distinctions as to the locations of discoverable statements and is focused instead on their possession, custody, or control. If a prosecutor brings a written witness statement or a medical examiner's paper copy of a report home from the office, it does not change the equation, and as we evolve into the digital age, their choice to receive, create, and store statements with witnesses or other discovery on their personal electronics equally carries no weight as of the Rule 14. So just because, yeah, again, we still can discover it just because they tried to hide it. That makes it even more the reason why we want to see it. Instead, the court should be focused on the obvious attempt to elude discovery obligations, sanction such actors when discovered, and make broad findings and pronouncements that such communications must be routinely disclosed, and when they are not, sanctions will be applied. So he should be in trouble just for not disclosing it to Aiden's attorney. Because it's so secretive, these conversations were one-sided, secretive, and hidden. It really bears some investigating, in my opinion. So, DA Morrissey's ex parte communication was a complaint to the presiding judge sitting on Mr. Carney's case, attributing negative conduct to Mr. Carney's on his private email. This knowing and willful violation begs the question whether there were equally discoverable responses from the judiciary. So, what did the judges say back? What were their responses? Did they say, hey, this is improper? Or did they say, yeah, no, sure, Judge, I'll make sure that he gets the book thrown at him later? I mean, there has to be some kind of a response from these judges, right? If so, did Morrissey cover them up or delete them? We need to know. The other obvious issue raised is whether there are other discoverable communications memorialized and hidden away on his personal devices. If I were the judge in this case, I would be like, you want his phone? You can have all of it. You can look at everything. You can look at all of his personal devices. I don't care. The fact that he was having these conversations is so corrupt. I'd be like, you know what? Cool. Have at it. Go ahead and look at everything. Have a full download extraction of his phone just to get even because I think it's so egregious what they're doing to him. Where D.A. Morrissey obviously engaged in a scheme to avoid discovery and public record scrutiny of his attempt to influence justices against Mr. Carney, he cannot now be trusted to simply agree and comply with the court's order. Yeah, so we can't just say, it can't just be the judge saying, hey, you know what, Morrissey, I know you didn't I know you had this discovery that you didn't turn over and, that's really bad, but I understand you're under a lot of pressure. So I'm going to let this one slide and just make sure you hand it over to him within 14 days, whatever. And then it doesn't happen, it doesn't get turned over. So you can't just like let Morrissey be in charge of turning it over. So I'm sure they're asking for this special master to keep Morrissey accountable. He cannot now be trusted to simply agree and comply with the court's order to provide all such communications when he has already been caught. Already been caught with his hand in the cookie jar. Can't take it back. And the trust is gone. So you need someone else to handle this. He has displayed a brazen proclivity to skirt public records and discovery rules. As such, he has shed himself of any presumption of compliance with the rules. Oh, I like that. He has shed himself of any presumption of compliance with the rules. The appointment of a special master to ensure compliance with a strong and broad discovery order is appropriate here. I think so too. I mean, it is. It's like it's the wolf guarding. No, wolf guarding the sheep. Is he going to be honest, or is he going to attack the sheep? It's the same concept. So part of such an order must include a Rule 17 summons to the source and the receptacle for all such communications. Apple Inc. Apple Inc. is a separate, neutral third party that can provide some measure of confidence that the items have actually been provided. So there's at least some kind of fail safe. So if what he's handing over is not on the up and up or looks like it's missing things, there's an Apple, there's data from Apple that we can compare it to see if he's not turning stuff over or if things have been deleted, at least in theory. All right, so in this respect, given D.A. Morrissey's subterfuge, there is no other trustworthy source to obtain the materials. Before ordering that a summons issue for such records, a judge hearing a Rule 17 motion must evaluate whether the Lampron requirements of relevance, admissibility, necessity, and specificity have been met. So we talked about this in my last video. We went through a bunch of different filings, mostly from the Commonwealth for Karen Reed, but they they're asking for Bill Reed and Janet Reed's cell phone records, the parents of Karen Reed, and they their arguments don't meet all four of the requirements for this Lampron requirement here. So specifically, Rule 17 requires that the party moving to subpoena documents to be produced before trial must establish good cause satisfied by a showing that the documents are evidentiary and relevant, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and that the application is made in good faith and is not intended as a general fishing expedition. So they need to meet all four of these. It's not one or the other, or a couple, or both, or whatever. It's all four. They have to get all four of them. To satisfy the first of the four requirements set out in Dwyer, the defendant must make a factual showing that the documents sought are relevant and have evidentiary value, and that potential relevance and conclusory statements regarding relevance are insufficient. Under Rule 17, the defendant must show that the documentary evidence sought has a rational tendency to prove or disprove an issue in the case. The second requirement imposes on the moving party an affirmative obligation to show that no other source likely exists for the desired records. The third and fourth requirements of the rule serve as a reminder that the limited purpose of Rule 17 is to authorize a court to expedite the trial by providing a time and place before trial for the inspection of the subpoenaed materials. Here, the statements and discoveries sought are potentially exculpatory and reasonably expected to provide evidence shedding light on prosecution bias and improper ex parte communications prejudicing Mr. Carney to the court, where DA Morrissey personally possessed and used witness statements, an order for him to personally provide all such undisclosed statements is warranted. In the circumstances, the defense is amply justified in asking for any and all information concerning statements and ex parte communications from the involved parties for cross examination, all relevant, powerfully exculpatory evidence. The information in the records is not obtainable in any alternative, trustworthy, and admissible manner, and prior inspection is necessary for a fair trial. The information request is based on the personal knowledge of the undersigned after viewing the aforementioned whistleblower information attached hereto. Finally, the records sought are not a general fishing expedition into immaterial areas. We already know that he was talking to people in ex parte communications, witnesses, and judges. So there's reason to believe that there could be more, and they've shown that, it exists already. So it's possible that there's more evidence within those files. So rather, the bias and potential bad faith of investigators and their collusion with witnesses for improper purposes is always relevant and admissible. For the foregoing reasons, the defendant asked the court to authorize the clerk magistrate to issue a Rule 17 subpoena compelling the production of the records as listed above and for entry of a Rule 14 order as requested. So they're asking for um, it's not they're not asking for too much. I think, they've shown that there's good faith to believe that there could be more communications in his secret personal email account. So, this is much better showing than the Commonwealth that just says, well, Karen talked to Bill Reed and she called her mom, so obviously she's guilty and we want to get more records so we can basically track her pattern of when she calls her parents. That's what they want to do, which is not legal. That's not the reason why you do discovery. You don't do a discovery dump just for to find patterns over a long period of time. But that's what they're trying to do, anyways, in Karen Reed's case. All right, so let's switch over here to Brian Tully. As you know, Brian Tully was Sergeant Buchanan's boss, and Sergeant Buchanan is Michael Proctor's boss. So that's how the totem pole goes. So Detective Lieutenant Tully, he was not on the text chain, by the way. The text chain, the famous, texts that, Michael Proctor got in big trouble for. Tully was not on those texts, but Sergeant Fanning was, or Lieutenant Fanning was. Lieutenant Fanning, he's a lieutenant as well, so he's, the same rank as Brian and didn't do anything, but he was not found to have any. It was like inconclusive or whatever their ruling was for Fanning in that case. But here we are. So Brian Tully, this is his punishment for not uh, n- not reprimanding his subordinate when appropriate. So let's read on here. It's not very long. All right, so Detective Lieutenant Brian P. Tully, Division of Investigative Services, Office of the Division Commander, having waived his right to trial by trial board for violating Article 3.76 and 5.82 of the Rules and Regulations governing the Department of State Police, is hereby ordered to comply with the following disciplinary action. Detective Lieutenant Tully, on or about February 1st, 2024, did fail to conform to work standards established for his rank, title, or position. So he didn't live up to being a detective lieutenant. He wasn't being a good supervisor of however many people he had, including Proctor and probably Buchanan. This occurred when Detective Lieutenant Tully failed to supervise through proper corrective action, SPDU Norfolk members, so it says members, two plural members, who were involved with inappropriate text messages relative to an ongoing homicide. This action is in direct violation of Article 5.8.2. This is a Class B violation. Detective Lieutenant Tully, on or about February 1st, 2024. So look at the dates: February 1st, May 6th, and May 10th. So this is 2024. This is this year. So this would be things coming out in pretrial hearings and things coming out at trial, perhaps, that he should have maybe acted on once he heard things coming out from this case, but he didn't. So, Tully, on or about February 1st, May 6th, and May 10th, did fail to recommend remedial or disciplinary action for inefficient, incompetent, or unsuitable employees by giving praise in several anchors to the employee evaluation system. So, he gave praise to employees who should have been told or should have been given probably lower scores and told where to improve and perhaps even put on disciplinary action. But because he failed to do that, this is where we are. So, despite evidence to the contrary and failing to document negative performance. So, again, they're only praising the employees that under Tully. I'm thinking this is both Buchanan and Trooper Proctor. Yeah, so that I don't know. what I was saying. Sorry. Um, so moving on, they're not doing negative, he's not listing negative things and he's only listing the positive, praising them for whatever when they really shouldn't be within the evaluation system for employees. So this occurred when DL Tully failed to properly evaluate members and did not properly document negative performance in the EES Make Note system. This is a Class C violation. As the result of his actions, Detective Lieutenant Tully shall forfeit 6 days of accrued leave. 6 days of vacation he's losing. Big frickin' whoop. Same thing with um, Buchanan Tully. I mean, Buchanan, no, those two are two different people. Detective Sergeant Tully, blah, blah, blah. Sergeant Buchanan. Heather, focus. My brain is not focusing. I'm starting to hurt a lot. So Detective Tully did not um reprimand at at any point in time when he saw his subordinates acting inappropriate, and then during the uh, employee evaluations, he was only saying good things about people that he knew did some inappropriate things. So he lost 6 days of vacation. I believe Buchanan also lost 5 or 6 days of vacation. Sergeant or Trooper Proctor is still, as we know of now, suspended without pay. They have not officially announced of any termination yet for Proctor. Kevin, Kevin Albert went back to Canton PD with we don't know what his punishment was. We were told at a select board hearing that his punishment would be given out by Helena Rafferty, and Helena Rafferty would not tell us what it was. So, and the board wouldn't tell us what it was. So we don't know what Kevin Albert's punishment was for driving around without or losing. Both Proctor and him were drinking and driving. Proctor was driving, and Albert lost his gun and badge that night and asked him about it the next morning. So there's that. And these cops are still cops, with the exception of Michael Proctor, who's basically in limbo right now. He's a nothing. But the rest of them are going to still put probably innocent people away because they've figured out how to do it. So, well, I don't think this one came easily, but I guarantee you this isn't the first time. If they thought that they could get away with it once, they probably have gotten away. I mean, this is like a much bigger, complex crime that they're trying to pull off, this cover up. But, in the past, I'm sure if there's just a little fudging that they can do with the evidence, and then, one thing little leads to another, and then they keep getting away with it, and they do more and more corrupt things. And here we are with this corrupt ass department who we still haven't heard any word on what's going on with the investigation into Enrique Delgado Garcia and how his injuries came about. And we still haven't heard anything recently for Sandra Birchmore, although I do believe there was a status hearing with Robert Devine. I don't think much came of that. I will have to take a look at that and make sure that I get that out there for you guys separately on the Sandra Birchmore playlist there. So that is all I have for you. Thank you guys so much for tuning in. Let me know what questions you have or what comments you have regarding this case, regarding Michael Morrissey's burner email, regarding Tully's very minimal punishment, what you think of that. I think he should have been fired. I think they all should have been fired, but that's just my opinion. I don't like to see people get fired either. Like, it's not like I'm hoping for people to get fired. I don't want that to ever happen to people, but if you can't do your job, and it's been kind of proven that you're not trusted to be able to do your job, Morrissey included, none of you should be in the positions, in the public service positions that you're in, because you can't be trusted. So, got to get rid of them. That's my opinion. What do you guys think? Would you leave them in their positions? Let me know in the comments below. I will see you guys in the next one. Thank you so much for watching. Take care. Bye now.